everyone. Welcome to today's program on justice, a lawyer's hangout where lawyers dissect legal issues with intent to create awareness, educate, and enlighten the public. I am Cecilia Meme, and joining me on today's program is my very learned colleague in the person of Chinonso Obasi. Welcome to this program, Counsel.
My pleasure being here. Thank you.
Yeah, and today we'll be discussing alternative dispute resolution in Nigeria. This topic actually stems from the place where an average Nigerian wants to go to court and doesn't want to utilize alternative dispute resolution mechanisms in the resolution of their dispute. So today we'll be discussing about it. Mr. Nonso, what is alternative dispute resolution and how does it differ from litigation in Nigeria?
Okay. From the question, alternative dispute resolution, that means there is a way ordinarily dispute has been resolved, which, as we know, it is by courts. You go to courts and there is a judge that sits over the matter and determines it's either in favor of the claimants or against the claimants. So, alternative dispute resolution suggests that there is an alternate way to go about resolving disputes than the ordinary court system. And that suggests that you could go through mediation, where a party or the parties can appoint one person to help mediate, bring both disputing parties together so they could resolve the issues. Or you have arbitration. Arbitration is more adversarial in nature. Or you have conciliation. So those are the alternate way of resolving disputes or contentions between two parties. So that is what alternative dispute resolution means.
So it is either arbitration or mediation or conciliation.
Yes.
Okay, so now what are the advantages and disadvantages of using ADRO mechanisms, particularly arbitration, to resolve disputes in Nigeria?
Okay, so what are the advantages? Now, it's tied to the peculiarity of the systems.
Okay.
For litigation, once parties are involved in litigation, you have more individuals involved. So it's not just two disputing parties themselves. You have to involve a lawyer. You also have to involve the judge. In the system of, or in the procedures of bringing your matters to courts, there are several parties that would also look at what you're doing. So you have the registrars of courts. You also have the administrative officers of the courts. You also have the bailiffs of the court that will go serve the processes. So, and then in the nature of the trial, there are day-to-day adjournments because it's not just your matter that the court is going to be looking at. So the court looks at the preliminary issues, the interlocutory applications, and then they adjourn and adjourn and adjourn. And when hearings is being done, it now adjourned for address and then judgments. So there are several adjournments and there are several things that bedevil the litigation process. So one of the things you get is adjournments. Secondly, it's and that dilatory nature of the adjournment, because the court is inundated with several other cases, and somehow they are understaffed as regards to personnel on the bench. And then you also have the schemes of the adversarial parties. The defendant's lawyer may not want to admit liability and also not want to come to court. So he keeps sending letters of adjournment of indispositions. So first of all, you have the advantage of arbitration is you could cut down on time and the dilatory tactics. Secondly, it gives confidentiality and privacies between disputing parties, because a bailiff that knows that shouldn't have business with knowing what is the dispute all about have access to those documents and can look at it. In courts, while the matter is done in public, any person or any party can walk into the courts and listen
Have
to
access.
evidences that has been given in trial, and they have access to informations that ordinarily
Ordinarily,
ought
they
not to be
shouldn't. Yeah.
available to the public. And then, so arbitration cuts down such
Exposure.
exposure. That is the second. So we have, first of all, it's time efficient. Second, it cuts down exposure and confidentiality between parties. It maintains confidentiality between parties. The third advantage, it's presumably less expensive,
Okay.
because for every arbitration, parties can come together. The disputing parties can come together and ask, this is how the arbitration is going to go. This is the fee for the arbitrator. So you're just paying basically
Whatever was earlier
agreed upon by disputing parties. And instead of engaging lawyers, that it can now go into appeal, and from appeals, it just keep going on and on and on without no time as to when this dispute is going to ever be resolved.
Yeah.
So those are preliminaries to the advantages of arbitration. And then it's majorly, for arbitration, it majorly works based on agreement of parties, how it ought to be done, what are the things that parties want, how the dispute should be resolved, and the way the parties think is best for the resolving of that dispute. They have say in it, but for litigation, you really don't have say as to how that should go. Yes.
Okay. So now, how enforceable are ADR outcomes, including the arbitral awards, and what legal framework generally governs the enforcement here in Nigeria?
How
How enforceable
enforceable?
are ADR outcomes?
I would speak on the earlier position of it in Nigeria. Initially, prior to 2023, it could be there are roadblocks as to enforcement, because while parties agree that they should go for arbitration and an arbitral award is given, arbitral award is the end result of the arbitration that has been issued by the arbitrator. Initially, a party can decide to not abide by the award given,
Okay.
and they can decide to challenge this award. But by virtue of the recent Arbitration and Conciliation Act, the Act has stipulated that the award is binding on parties. And the only time you can come to challenge the award, you must prove that there is miscarriage of justice by the decision of the arbitrator.
Okay.
So ordinarily, that's by the Act, it gives a force of enforcement that these things should be, and ordinarily should be carried out, the award should be carried out by parties that the award was made against. So arbitral award generally in Nigeria is enforceable. Yes, and it is recognized by the courts.
Okay. Okay, so now for the sake of clarity, what legal framework governs arbitration and their enforcement? I think you mentioned Arbitration and Conciliation Act.
Yes, and there are several other laws that governs it.
Okay.
There is the Petroleum Act. Several acts that has come into being have also featured or tried to feature resolution of dispute by arbitration.
Okay.
So some of them have stipulated that where there are issues between parties as respects to their transaction, they should first go for arbitration. So those acts, to an extent, give arbitration some level of enforceability. So you have the Petroleum Act, you also have the Lagos. There are now several rules of courts, the multi-door courts house, and the rules of court also give openings to arbitrations and enforceability of those arbitrations that is being provided for in those acts. So there are several acts in they're very replete in the Nigerian legal system
Okay.
that stipulates for arbitration and the enforcement of such awards once given.
Okay, so now the by going by what you said now, the main legislation is the Arbitration and Mediation
Yes,
Act,
Arbitration and Conciliation
Arbitration
Act.
and Conciliation Act.
Yes.
Okay, then we also have other laws by virtue of certain industries that
Yes.
also provide for arbitration.
Arbitration.
Okay,
Exactly.
now what is the general attitude of Nigerian businesses and individuals towards AGRO methods?
First, there are different kinds of persons recognized under the Nigerian law. There are natural persons and there are corporate persons, artificial persons. So, for the natural person, an average Nigerian feels, and by the structure of our laws, an average Nigerian is emboldened to go to courts
Okay.
and is reclined to refuse arbitration.
Arbitration.
Reason being that by the Constitution, it gives all authorities, all parastatals, all bodies the right to enforce every court decisions that has been granted by the courts. So, by the virtue of that section in the Constitution, once they go to court and the court gives a decision or gives a judgment, it is enforceable by any person and any authority in Nigeria. So you could take that court order. Ordinarily, there are processes for enforcement, but if you take that court order to the police is the executive arm of government. Their duties is to maintain law and order, which also means to execute the laws that has been given or that came from the court system.
Okay.
So if you take that order of court to the police naturally will be inclined to enforce that order. That on its own emboldens the Nigerian, an average Nigerian, to go to court. And to an extent, it's a show of power. And an average Nigerian is egoistic, naturally. And they can decide that this is what, and because of it is popular by means of patronage, that is what people ordinarily go to. So
Yeah.
they are more inclined to adopt that system, litigation. But the corporate entity or the corporate person, on the other hand, especially large corporations that their businesses are tied towards customer patronage, are more inclined to protect their trade
image.
secrets,
Yeah.
to protect their image, like you said, to also have an end to litigation, to cut down costs. They would be more willing to adopt arbitration. So it depends on where the pendulum swings and what is the opinion and worldview of whoever approaches it. And with the current Arbitration and Conciliation Act, I don't see reasons why anyone
shouldn't adopt
arbitration.
So what it means is that we should encourage Nigerians to actually utilize alternative dispute resolution.
Yes, because much more alternative dispute resolutions, you are dealing with skilled personnel to preside over your case.
Okay.
I would give you an instance. There was a time I had a matter that has to do with oil and gas. And the judge before whom the matter was brought, I don't think that person had experience, in-depth experience, skill, exposure, dexterity with handling such cases. So you take more time to explain what this matter is all about before the judge, before the person can decide to understand the peculiarities and nuances with that subject field. So those on its own are roadblocks to why a person should not choose litigation, because you don't determine who the judge is. But for arbitration,
you can determine
yes,
who the arbitrator is. Okay, let's quickly go on a short break, and when we're right back, we'll continue our conversation on alternative dispute resolutions in Nigeria.
Hello everyone, welcome to Ice Clothings, the ultimate fashion hub for men. Elevate your style, elevate your confidence. Where stars meets sophistication.
Our tellers crafts with precision and cares. From formal suits to traditional attire, our extensive collection has got you covered. Visit us today at Ice Clothing.
Ice clothing, where fashion meets perfection.
Welcome back from our break. Thanks for staying with us. Before we went on break, we were discussing about the general attitude of Nigerian businesses and individuals towards ADR methods. And like my colleague rightly mentioned, depending on where the pendulum swings, for corporate entities, they prefer utilizing ADRO. For individuals, there's still a little bit of recline towards utilizing it. But however, we also encourage individuals to utilize ADR and always not run to litigation immediately they have any disputes to settle. So now moving on, Mr. Nonso, how can one initiate an ADR proceedings? And what are the key elements of a valid ADR agreement?
Okay, so the second question deals with the first.
Okay.
So, how do you institute an ADR
Yeah.
proceedings? First of all, foundational to every ADR proceedings, arbitration particularly, is the agreement of parties.
Okay.
So the agreement of parties can issue from a contract entered by parties. And in that contract, it is stated that once there is dispute between parties, that parties shall first recourse to ADR in the settlement of the dispute.
Dispute. Okay.
So the first recourse shall recourse to ADR. It's an arbitration clause that gives room for parties to explore ADR. So parties are, and by assenting to that terms or to that agreement, it means that parties are at consensus to that particular issue. So when there is a dispute in future, parties can decide to draw out the terms of ADR, of arbitration,
Okay.
and they can decide at that point of arbitration who is going to be the arbitrator. They can decide the time frame within which this arbitration is going to take. They can decide on where the arbitration is going to take place. They can decide on the law that will be binding the arbitration agreement,
Okay.
the arbitration process, and they can decide on several other issues by the terms of that arbitration, the terms of the arbitration, and after which the appointment of the arbitrator is being made, and there is a resolution as to who takes the burden or the charge of the arbitrator.
Arbitration.
It can either be by a tribunal, it can be by a panel,
Okay.
an arbitrator panel.
Okay.
It can also be appointed by the courts,
Okay.
where they are not at consensus as to who will be the arbitrator. And that's when the court appoints an arbitrator, there are certain things that they factor in. I think we'll discuss it later on, I don't know. But there are certain things that is being factored in. Once the arbitrator is being appointed, the arbitrator calls the party, they sit together, and there's an underlining of issues by both disputing parties. What are the issues in
Question.
question, and what are your facts? Then there is more like a front-loading system. Parties
Okay.
settle issues, parties bring up facts, and parties now tender their documents or what witnesses that would be available in the settlement of the arbitration
Yes. Okay.
or settlement of their disputes. And once that is done, then the arbitrator gives a schedule of how hearing is going to take place.
Okay.
So that is primarily how arbitration is being
Carried out.
carried out. So for the second question, if I
The
get
key
it right,
elements.
the
You've
key
actually
elements,
mentioned this in
yes,
passing.
key element should be the agreement of parties. Arbitration is more like a contract. There is going to be an offer, there's going to be an acceptance, and then there's going to be a consideration.
Okay.
And then parties must be willing that's
To submit.
to submit to the arbitration,
Okay.
and that arbitration process should have the force of the law. So those are the elements of arbitration.
Okay, when it comes to with regards to mediators and arbitrators, are there any specific qualifications they should possess?
Yes. First, they must be skilled in the subject of the arbitration or the subject matter in question.
Okay.
So they must be skilled, because most times those arbitration have to do with issues of law also.
Okay.
So in a situation where it is a sole arbitrator, it is often required that that sole arbitrator should be a lawyer,
Okay.
and that person should have the requisite skill to arbitrate. Where it is a panel, there are more than one person, like a 3 arbitrator panel. It is required that one amongst those 3 is a lawyer.
Okay.
Now, where is a court appointed arbitrator, the person ordinarily would be a lawyer and has been trained to be an arbitrator. Also, if it's a professional body, by professional body, it means the person is affiliated to that body and the person has also the requisite skill. But more often than not, arbitration always goes with persons who are skilled in that subject, and the person who also has the requisite legal knowledge to distill legal issues and factual issues.
Okay, so an average Nigerian out there doesn't think that arbitrators are just anybody.
No, it cannot.
They are very skilled in arbitration.
Yes.
Okay, so now this brings me to our next question. Can parties appeal ADR outcomes? And under what conditions?
Oh, yes. Parties can appeal ADR outcomes.
Okay.
Reason being, initially, it used to be the law that where the arbitrator is seen to be partial
Okay.
and not fair, that such decisions emanating from such process is appealable and can be set aside.
Okay.
But by reason of our current law, I had said this earlier, that the grounds upon which you can appeal or you can set aside a decision of an award, of an arbitral award, is going to cause miscarriage of justice. If that stands, there are some other grounds upon which an arbitral award or an arbitration process can be appealable or can be appealed. One of which is when the arbitrator goes beyond the powers allocated to him, or when an arbitrator resolves that issues that are not before him.
Okay.
So they're given a schedule or a scope of duty to the arbitrator. Parties have agreed this and this is the dispute before you. This and this is what we intend to resolve. And you look at the dispute and you start going haywire as to start going to
Outside
town
scope,
outside
yeah.
the scope of what you're called upon. So a person can decide to go to court, appeal that decision, and have it set aside.
Okay. So now, to what extent does judicial interference impact ADR processes?
Judicial interference means the courts.
Yeah.
How does the court interfere with ADR processes? As much as parties would want the court to interfere, that is the general note on it, because the court would have no business dealing with an arbitration process if one party to the arbitration did not come go to it. So it is dependent on the parties, and for what is what, the court would not close its hands to an award that is being brought before it when that award is contrary to public policy.
Okay.
One. Secondly, the court also guards the democracy and the sanity of the community or the citizens at large. So, where the court also upholds that sovereignty of a state. So, where there is an arbitration, an arbitral award that has been entered by a, a tribunal or an arbitration panel outside the country, and such country has no reciprocal agreement as to the enforceability of such of arbitration award with Nigeria,
Nigeria.
the court is not bound
To abide by it.
to abide by it. And
Okay.
once you bring it to the court would ordinarily set it aside.
Okay. Okay. So now, what are the emerging trends in ADR, including digital dispute resolution, and how might these affect future dispute resolution in Nigeria, if any?
Emerging trends.
Yeah, in ADR.
Nigeria, by its nature, we are not so welcoming when it has to do with the orthodox practice of resolving disputes.
Dispute.
So we've not even embraced the arbitration properly. And now arbitration in other countries, in other climes, are piecing up with digital trends, more like they have remote proceedings. And now where it has to do with settlement of issues and reconcile what issues are between the parties, they now use AI to reconcile the issues. And then it is now submitted for parties to decide on what to do with, for the arbitrator to decide on distilling what is properly the issues in question. So all these things are emerging trends. Now, you don't need to be in the same room for examination, because in arbitration there's also what's called hearing.
Yeah.
Parties bring their witnesses and they are being cross-examined, documents are being front-loaded, they are challenged if need be. So all those things, you don't need a party to be in the same room or the same ambits in order for that proceedings to go on. So with that comes the challenge of aiding of witnesses.
Okay.
So if a remote proceeding is going on, you're in India and someone else is in Mexico, the other party is in, the arbitration panel is in Nigeria, and you're taking proceedings online, how are you sure that person, the witness that is in Mexico, is not being aided?
Sure. That's true.
So with all this comes the trends that necessarily people see as a roadblock. And Nigerians, in its way, in their fashion, have cold feet embracing such. So emerging trends, they are emerging trends, and Nigerians willingly are able to accept those emerging trends. I think time will tell.
Time will tell. Thank you for staying with me on today's program. Yeah, to our viewers out there, as a Nigerian, we shouldn't always sit towards running to court when issues arises or where there are disputes to be resolved. Aside from litigation, there are also alternative dispute resolution mechanisms that are set in place. There's arbitration, there is mediation, there's conciliation. So parties at dispute can actually negotiate their way out of some of these issues. So we should unburden our courts and try to adopt alternative dispute resolutions. Thank you for staying with us, and remember to follow us on all our social media platforms. Thank you to Mr. Nonso once again for joining me, and I hope you enjoyed our discussions. I remain your host, Cecilia Meme. Bye for now.